All right, just we the people of news. Not attorney, not giving legal advice. Just opinion. I'm hearsay. Videos are hearsay. Okay, this is going to be a two-part video as well in the same one. Of course, you're going to see me switching it. Just giving you fair notice. All right, but it kind of runs together because some of us, gets a little nervous why we're in court in our persona, in our own person. Okay, and we don't do these things every day. So what I am led to believe and do believe as how is the best benefit for you. So let's start with this one for argument's sake. We're not going to watch the whole video, but it's a court case and it's about a motion.
So they'll appear right behind you if you're okay sitting there. Okay. So I'm going to take up with your case. This is the state.
By the way, this is power inherited in the people. Okay, check out his videos. There's more along the lines of a non-driver, a traveler. All right, so check out his videos. It looks like he's got a lot of great content. Go, go, go.
Of Washington versus Lewis Ibarra, cost number 24-1-332-33. We are set on for status and for Mr. Ibarra's motion to dismiss, correct? That's correct. Now, as far as status, I just want to make sure I am looking at the latest and greatest dates. I'm looking from an October 22nd, 2024 order on arraignment that we have our trial date of January 15th and our expiration of January 20th. Those are the most current dates. That's what I heard. Okay. Now, I have the motion to dismiss, and I have the.
By the way, this has been a video out there, a non-driver but a traveler, and got harassed by the officers because of his private tags on there, and they call it fraudulent deal. They can make any excuses up, people.
Yeah. I think statement of fact, an amended statement of fact that goes with that motion, and I have the state's opposition to the motion, and I have a reply to the state's opposition to the motion to dismiss. Is that everything you think I should have? Yes. And did you have anything else that I should be considering, Mr. Christensen, or do I have everything? Okay. And so, Mr. Ibarra, do you want to make a brief argument on your motion for the record?
Yes.
Okay, go ahead.
Yes. Well, I'll just it was just so crazy to just see my constitutionally protected rights violated. As I was just on private property, just putting gas in my truck, and
Okay, so I am going to. I know you're representing yourself and you're proceeding pro se.
Okay, listen to this part because it's very important as well.
But just for the record, I do want to advise you and give you the caution that you do have the right to remain silent and that anything you say can and will be used against you. And you don't have to say anything.
Okay.
Okay.
Yeah.
But if you want to make an argument on your motion, and I know you're representing yourself, so go ahead.
Thank you. Yeah. So well, one of the main rights that were violated was pretty much the officer coming up to when there was no verified complaint. There was no third party called saying that I've hurt somebody or damaged property or did any type of wrong to anybody, and they just came up to me and started harassing me. They didn't just do that, but they were prejudiced against me. They labeled me a constitutionalist, and just to see that with my family, it's just so messed up, to be a part of this and just see how how the cop violated my rights.
All right, so
Just I'm not done. Yeah, they labeled me a constitutionalist. They did police misconduct. They harassed me. They did an overreach of of police power. They took my private property, my personal private property, without due process. They pretty much treated me as if I was guilty before proven innocent, and they completely um, overstepped their boundaries and went against my constitutional protected rights. They also, the loss of property that was my only form of travel for my family and I. You know, them taking my flatbed trailer, it has caused a lot of harm. That's what I actually use.
Okay, so in this case, he's really nervous. And the reason why I'm making this video is sometimes it's best to keep it on paper and not say nothing in court. And because the judge is going to do what it's going to do anyway. All right. Now you can object or you can deny. I deny your claim, or objection because they're out of order or putting something that's out the side of the four scopes, the four corners. But I am led to believe that denial of what they are saying kind of still puts a burden on them to prove, you know, uh, their claim, okay, their evidence, and all that kind of stuff. And ejection is more of along the lines just to get it rotated into another hearing. In this case here, the judge did deny the motion. Surprise, surprise. All right, so lower courts, you're not going to get really any type of justice in the first courts in most cases. All right. But the point I was going to make on this is we're going to kind of pause it here. So if you want to see the whole video, put it on my deal, and I'll go through here and make a couple of videos that shorten it down to see it, or you can go to Power Inherent in the People. All right, but he's got a lot of great content, and this guy here, let's see here, this guy right here has actually read us his paperwork, and you guys got to hear that for yourselves too while they're going through it. It's really good. Okay, I'm not even going to get started why the judge denied it. We know how that goes. So, this is the reason why sometimes you want to keep your mouth shut.
Create attention-grabbing videos with millions of creative...
Of course, after we're going to go through this process.
we're here to...
All right.
Did you get my notice?
Sorry, jump from the beginning.
Did you get my notice?
Our notice, sir?
I'm not a sir. Can I have a seat?
Have a seat, please.
Did you get my notice?
Your motions that you filed, your notices that you filed, yes, the court has reviewed them. I'm calling court case 19 CM 1570. State of Wisconsin versus Ryan Robert Desmith. He is appearing.
All right. So, you can read on the side here. Number one, you have a Second Amendment right. He shouldn't even be going through this process. Okay? And my train of thought just left. And again, I do these things at the spare of the moment. You notice right there, he automatically jumped into asking the judge or magistrate, which I'm led to believe it is, magistrate, did you get my notice? Did you get my motions? Right? He wants to verify that she's actually going through the paperwork and make a center listening on one side and the other on the paperwork. People don't realize this in most cases, but the paperwork itself is court. All right? They are supposed to read the paperwork and kind of finish the last minute argument, okay, for the judge to kind of make its final decision. But she's already supposed to read both sides, and they don't read yours. They just don't do it. That's the reason why I say you use these trickery words in there, whatever you want to say, you know. I caught you cheating on your husband the other day, you know, or as it being a female or whatever judge here, right? You put these in and put little trickery words to verify whether they read it and you want to bring it up, right? Or did you get in there where, you know, you, you know, was cheating on your husband and all that to kind of decipher and make sure it's been read, right? Trickery. It's all tricks.
In person without counsel. Assistant District Attorney Hannah Schuckert is appearing for the state. This is an initial appearance, and we're here today. Sir, have you received a copy of the criminal complaint?
I stand on my notice.
Did you receive a copy of the criminal complaint?
I stand on my notice. Sir, it's a lot easier if you just answer the question.
Now listen to him, right? She's asking questions. I stand on my notice. I stand on my paperwork. Okay? He does not have to speak. The paperwork is speaking for him. So even when you're nervous and scared, you can always convert back into telling the judge, I stand on my notice. And it probably would not hurt when you sit down, you verify, prosecutor or the claimant, did you get a copy of my notice, my motions? Get them to say yes or no. All right. It's what he did with the judge. But I'm all for you telling the other party, the other side, that's supposed to be making these claims, because you're alleged defendant. You're not a defendant. You're alleged defendant. Okay? So always be clear. They got your notices as well, and you want it for there on the record.
You got my notice.
Did you receive a copy of the criminal complaint, sir? This is a very simple question. I called other cases before you so that you could understand how the court process is proceeding. This is a very simple question. You were sent a criminal complaint.
We talked about this in other videos again, right? What is she doing right now? Recognize these things when you go into court. She is compelling him to answer her when anything you say or do can and will be held against you in a court of law. Y'all, sit and think about these things. She's getting frustrated because he's not answering. He's not answering because anything he says or do was going to be incriminated against him.
And a summons. And you are being charged with carrying a concealed weapon, party to a crime. That is a Class A misdemeanor. If you are convicted of that crime, you could be fined not more than $10,000 and imprisoned not more than 9 months. Count 2 is obstructing an officer, party to a crime. If you are convicted of that, that is a Class A misdemeanor. You could be fined up to $10,000 and imprisoned not more than 9 months. You are also being charged with disorderly conduct, party to a crime. That is a Class B misdemeanor. If you are convicted of that, you could be fined not more than $1,000 or imprisoned not more than 90 days. Now, knowing what you've been charged with and the maximum penalties, you have certain rights. One of those rights is for the state to prove these allegations against you in a court of law. You are also entitled to have a court trial or a jury trial. That is of your choice. You are also entitled to have an attorney represent you. If you are not working, you can apply to the state public defender, and then an attorney can be appointed for you. If you do not qualify for the state public.
Now listen to her voice. She kind of using her hand, tapping on her desk. She is frustrated. She is not getting her way. He is in control of this court right now. And most people don't even realize this. But you sit and think about it. Okay?
Defender, you have several other options. One of those options is to defend yourself. Another option is to hire an attorney. If you call around and realize that you cannot make the retainer to hire an attorney, you can then come back to court and fill out a form for a court-appointed attorney. The county would then appoint you an attorney if you qualified, and then you would be responsible for paying back the county on a monthly basis for the attorney. Now, those are your rights, sir. This is the purpose of today's hearing. So, I need to know, do you plan on hiring an attorney?
Right? She is still trying to compel him to answer her.
I don't understand what you're saying. I don't speak your language, I only speak man to man.
Okay.
Right? Because she's a fiction. She's in wolf clothing. All right? She's part of a corporation. And corporations cannot charge a man, cannot sue a man. It has to be another man to another man, another corporation, another corporation. This is the reason why the person's involved, so they can kind of come in and actually do these things. Because if you agree you're a person, you agree you're some form of a business entity. So they're bringing charges under the administrative because you are a corporation that you're not arguing.
You got my notices?
Sir, those notices can be addressed upstairs in circuit court. At this point, I've told you the purposes of today's hearing.
All right, let's go with part 2, 17 minutes. These are We the People News.